legal system.
Well, I'm going to have to stay down. Stay down. I'm going to stay down. We take the thing, man.
Quotation matters in court. It locks meaning. Survivors told Larry Nassar in a packed Michigan courtroom there was nowhere left to hide. More than 160 victims stood behind the record. The judge enforced decorum when a father asked for 5 minutes. That moment sits on the line between grief and the rule of law, and you feel how due process keeps the room from breaking. And in Nebraska, I killed her. I didn't mean to, but I did. Aubrey Trail's admission forced jurors to weigh words against the wider record: surveillance, witnesses, and charge sheets. Watch how specific phrases, under oath, can redirect everything that follows.
Legal
Well, I'm
system.
going to have to stay down.
So let's put that pressure under the lens. Nassar sentencing, when prestige meets a packed courtroom. You've watched outrage trend online. Here, it had to move through microphones, case files, and a judge who would not let emotion rewrite the law. Larry Nassar sat at defense counsel, a former physician for USA Gymnastics and Michigan State University, a man who hid his crimes under clinical pretense and access. The record shows years of exploitation of trust inside elite sport, and a courtroom finally packed with survivors ready to speak. More than 160 who came forward. This sentencing drew national attention because the scale was undeniable and the institutions were out in the open. The thing about this case is prestige can dull alarms. Verified reports show that proximity to medals and titles creates blind spots. Policies that look strong on paper can be weak in practice. Complaints stall when power controls the pipeline. At MSU, reports had reached officials as early as 1997, long before termination. That's the pressure point you're seeing. An arena that once shielded a doctor now had to sit for sworn statements, one after another, under a judge's supervision. Now let's look at the procedure. A sentencing hearing is designed to hear victim allocution. Survivors have the right to speak. The judge has the duty to keep order. The evidence suggests that due process at this stage is a checklist. Miss a step and you risk appeal, delay, and a fractured outcome. The judge in this hearing structured the process to let the record breathe. Statements cataloged, exhibits logged, and the defendant's convictions already secured. Concrete consequences were already underway, tied to violations of federal child exploitation statutes like 18 U.S.C. Section 2251, which prohibits producing child pornography, and Michigan's criminal sexual conduct laws under MCL 750.5 20B for first-degree assaults. Nassar's repeated medical manipulations breached these by crossing into non-consensual penetration and abuse of minors in his care. The record shows a federal sentence of 60 years for child pornography entered first, followed by state terms measured in decades, 40 to 175 years, based on sexual abuse convictions. Restitution orders followed, complicated by incarceration and the logistics of accounting. The order totaled nearly $60,000, yet monthly payments hovered around $8, and more than $10,000 remained unaccounted for inside the system. None of that erased what survivors described, but it set the legal frame: punishment, accountability, and a public record that could not be sealed by reputation. Then the room flexed under human grief. A father stepped forward. He asked the judge for 5 minutes with Nassar. That sentence cut through the protocol and laid a raw demand on the bench. Court officers moved. The defendant stayed seated. The judge acknowledged pain but drew the line, emphasizing order and the rules of the forum.
But in a courtroom, we don't use profanity, but if you have some words that you would like to say, I would like to give you the opportunity to.
The message was simple. You can speak on the record, but you cannot turn this space into an arena for retaliation. Why does that matter? Because the courtroom cannot let a second crime overwrite the first. Security and decorum protect everyone's rights, including the survivor's right to be heard without chaos swallowing their statements. Judges have tools for this exact moment: admonitions, recesses, measured rulings, to absorb emotion without letting it redirect outcome. If the court fails that test, a defense team can argue prejudice or procedural error. If the court passes, The testimony stands and the sentence survives scrutiny. Speaking of evidence, the national spotlight landed here because layers finally align. Survivor accounts, institutional records, and prior judgments. The evidence suggests that institutional protection crumbled under sustained exposure. Sworn statements, corroborated documents, and a judge who insisted on transparency. Prestige met a public ledger. It did not win. Think of due process like a flight checklist. You verify fuel, controls, weather. Skip one box and you don't take off. In court, miss a warning, skip a foundation, or let disorder taint the record, and the legal flight risks turning back. Reversal, remand, or delay. The judge's job is to keep that list intact while letting the truth come out in full. That father's eruption now reads as a symbol of public morality colliding with legal ritual. The defendant had already admitted wrongdoing through convictions and pleas on the books. So the question turns, what does the system do with righteous anger? It documents it. It channels it into legally recognized statements. It holds the line so the words stay admissible and the sentence stays enforceable. The room held, the record stood. Truth entered the file without a second crime splintering the proceeding. And that gives you a clean lens for the next flashpoint, what a single rupture can reveal about the machinery of procedure when a hearing starts to shake. Andrew Wirth, a flashpoint exposes procedure under pressure. You're about to see how a bond hearing, not a trial, can become the moment the system has to prove it can hold the line. Who is Wirth in this proceeding? He's the defendant charged in a double homicide, the killing of off-duty police officer Jennifer Lewick and her boyfriend Greg Peters, after an altercation that began at a bar. The record shows Lewick playfully grabbed Wirth from behind. He took offense. Hours later, shots were fired and both victims were dead. That context explains the posture of the court. High stakes, a heavy charging document, and a courtroom watching for any sign of escalation. The flashpoint came when the judge set bond at $1 million on the double homicide case. That figure wasn't abstract. It reflected risk, the seriousness of the charges, community safety, and the likelihood of flight. As the amount was announced, Wirth turned toward the victim's family, echoing violations under Wisconsin Statute Section 939.62 for homicide by negligent use of a dangerous weapon, which covers reckless discharges leading to death. His courtroom lunge breached decorum rules in Section 757.19, disrupting judicial proceedings through direct threat. Deputies moved instantly. The evidence suggests he was tackled and tasered to contain the disruption. You can read the line of duty in that reaction. Keep people safe, secure the defendant, and preserve the record. Now let's look at the procedure. Bond hearings move fast but follow a checklist. Confirm identity, read charges, set conditions, and state reasons on the record. Judges weigh statutory factors, gravity of offense, ties to the community, prior record, risk to public safety. A double homicide involving a police officer magnifies each factor. If a defendant reacts physically, the court's tools are immediate. Verbal commands, restraint, removal to holding, and if needed, summary contempt for conduct in the judge's presence that disrupts proceedings. The goal is containment without compromising due process. The outburst here wasn't just noise, it was evidence of volatility that can justify tighter conditions. The record shows deputies intervened before the exchange could escalate, and the judge's ruling on bond stood. That's the key detail. The court treated the incident as a procedural event with public safety implications, not as proof of guilt on the homicides. If a court let the room break, an appellate court could later question whether prejudice tainted the process, keep order, and the ruling survives scrutiny. Speaking of evidence, the charging posture shifted over time. Wirth initially faced first-degree intentional homicide counts, which carry the harshest possible penalties, but convictions landed differently. The record shows he was ultimately convicted of homicide by negligent use of a dangerous weapon and sentenced to 10 years in prison. That gap between initial allegations and final judgment illustrates how the legal system calibrates culpability through trial, negotiation, and proof standards. The early bond and courtroom security decisions still made sense given the risk profile at the start. Let's break that down. Bond isn't a verdict. It's risk management. If the offense involves a police officer's death, pressure increases. Courts respond with higher bond, closer supervision, and tighter decorum. If an outburst follows, corrections tighten further, restraints, more deputies, limits on movement in the gallery. The record shows this exact sequence. The hearing stayed on the rails because the judge and security treated it as a controlled emergency. The evidence suggests courts are built to absorb emotion without mirroring it. Admonitions restore the baseline. Removal protects the families and the staff. A short recess lets counsel advise the client. Stay silent, defer to counsel, and preserve the defense. If the behavior crosses the line, sanctions follow by rule, not impulse. That's how you keep an inflamed moment from contaminating the rest of the case. What should you take from this? A courtroom can face a lethal backstory, a charged gallery, and a defendant under extreme stress. If the judge keeps the focus on articulated reasons, probable cause in the charging documents, statutory bond factors, and clear findings, the proceeding remains lawful even when the temperature rises. Wirth's case shows the split screen, a violent allegation, a high bond, an immediate rupture, and a final conviction that reflects a different level of criminal responsibility than the opening charges. Moving past the Wisconsin Flashpoint, shift your attention to what words alone can do in a murder case. You're about to hear a sentence spoken in open court that didn't raise the volume, but redrew the legal map.
I curse you all.
A defendant's own phrasing can narrow the path ahead, and that's where Aubrey Trail stepped in. Words that rewired the trial. You heard a sentence in open court that did not raise the volume. It changed the stakes. A single admission can rewire a trial when the file already holds surveillance logs, witness statements, and a potential death sentence. The question is what the law lets jurors do with those words and how the rest of the evidence shapes their meaning. The thing about this case is the framework was heavy from the start. Nebraska prosecutors charged first-degree murder under Nebraska revised statutes, Section 28-303, which requires premeditated intent and abandonment of human remains per section, 28-1291, exposing capital punishment under the state's aggravated murder provisions. Trail's ritualistic claims and coercive tinder setup breached these by evidencing deliberate luring and concealment to evade detection. That pairing signals intent on one count and post-offense conduct on the other. It also signals capital exposure. With that, every procedural step tightens. The court schedules advisements, the judge confirms counsel. Discovery moves under deadlines that preserve due process because mistakes at this level echo on appeal. Let's break down the path to trial. The record shows appointments of counsel, bond decisions tied to risk and the gravity of the charge, and a docket that moves through arraignment to pretrial hearings. In capital-eligible cases, the court polices timetables and resources with special care. If a defendant hints at pro se elements, speaking on their own or filing personal motions, the judge can allow it with standby counsel, so the right to self-representation does not wreck trial integrity. Every move is logged so the transcript survives scrutiny. Tension built because Trail's narratives kept shifting. Early statements floated an accident. Other versions leaned on ritual claims. He told investigators that about half of what he says is garbage. He publicly claimed he was a vampire with special powers, and that recruits would need to kill to fully become witches. He also asserted that he and Bailey Boswell knew Loof months before the Tinder date, and that he was trying to bring her back into their group with offers of financial help. When those versions meet the courtroom, the judge filters them through the rules. Statements outside oath and outside the stand do not carry the same weight. Inside the courtroom, under oath, the calculus changes. Speaking of evidence, the state's mosaic was broad. Surveillance placed movements before and after the crime. Witnesses described control, planning, and references to a so-called covenant. Prosecutors presented items they said showed preparation and intent. Each piece stood on its own foundation. Who saw what, how it was documented, and whether the chain of custody held. None of those witnesses claimed to be present at the moment of death. That matters. Without an eyewitness to the act, the jury audits corroboration against a defendant's words. Now let's look at the rules that govern those words. Under the evidence code, admissions by a party are not hearsay. Translation, If the defendant speaks in court, jurors can consider it directly. They weigh it alongside the exhibits and the testimony, with credibility as the filter. An unsworn outburst is one thing, sworn testimony is another, and a clear admission under oath. I killed her. I didn't mean to, but I did. Lands in a category the law knows how to handle. Add one more layer, the spectacle around the stand. 2 weeks before his testimony, Trail slashed his own neck in the courtroom. That incident did not enter as proof of guilt, but it colored perception of his stability and underscored the judge's duty to keep order. When he later took the stand, jurors had already seen a defendant under visible strain. The court responded with tighter security and firm instructions to compartmentalize emotion from proof. Think of it like a lock with 2 tumblers. The first tumbler is corroboration, videos, phone data, physical items, and witness accounts that align. The second is the defendant's own statement. When both click, the door turns. But if credibility on the second tumbler is damaged, because the speaker told multiple stories or embraced claims of vampirism and witchcraft, jurors test the fit harder. They compare phrasing to timelines. They look for overlap with independent records. They decide how much weight to give. So does an in-court admission resolve doubt or create new questions? The evidence suggests it becomes a pivot point, not a finish line. Intent still matters. Planning still matters. The state alleged a larger pattern that went beyond a single moment. The defense had to navigate narrowed lanes once the statement entered the record. Strategy can shift toward mitigation, mental state, or the meaning of intent under Nebraska law. Meanwhile, the judge safeguards the process with instructions that keep jurors focused on admissible content. Why speak after offering other versions? Pressure builds when records converge. Surveillance timestamps do not bend. Digital traces do not forget. Counsel anticipates what the jury will see and hear. A defendant may try to seize narrative control, even late. That choice can close one door while opening another, and the court's job is to keep the corridor straight. The through line is clear. When control meets consequence, the courtroom becomes the filter on one side, spectacle and shifting stories. On the other, a transcript built to be audited. That's where the system does its quiet work, absorbing emotion, enforcing rules, and turning contested facts into a public record 5. The through line across Nassar, Wirth, and Trail is simple. Courts have to balance human emotion with legal procedure in real time. When prestige, arrogance, or abuse corrodes trust, the transcript becomes the remedy. Due process works like a checklist. Skip a step and the case risks collapse. So here's the question for you. Where should courts draw the line between human grief and strict decorum? Put it in the comments and tell me how you'd set that boundary. If you want more deep dives into justice and procedure, hit subscribe. The next case may hinge on a single sentence and on how a judge applies the rules. Subscribe and follow Red Tape Red Flag on all platforms. And don't forget to like, share, and comment.